Good morning, everybody. Welcome again to the contract law lesson. Nguyễn Thái Cường report from Institute of Intellectual Property and Competition. And today we're going to study a new subject concerned to contract law. So what is contract law? Some legal document we have the Civil Code 2005, 2015. Lesson objective. In this term, we understand about the basic knowledge about general concept of Vietnamese contract law, understand about contract formation, understand about validity condition of contract, voidable contract and legal consequences, understand about the term of contract, and lastly, understanding about the validity of the contract. Concept, characteristic, classification. Concept. According to Roman law, the contract is an agreement of unity purpose between the party. They have a common goal. According to Article 385, contract means an agreement between parties in relation to the establishment, modification, or termination of civil rights and obligation. What about a characteristic? Firstly, there must be a civil transaction based on a party mutual agreement upon shared will. They have a legal binding between the party and a general purpose for each contract type. Distinguish between agreement in a contract and agreement in not a contract. Example 1, A invite P to his pool party and B agree, but there doesn't come. It's not a contract. Simple an invitation. Example 2, a purchase good and receive the good but did not pay. It must be a contract. Classification of contract. Before we go to classification, we see an example. So we see here, according to traditional common law, there must be an offer and acceptance. So the condition, we need to give an offer and we need to have an acceptance. Classification of contract. Article 402 of Civil Code 2015, we have the bilateral contract. We have unilateral contract. A bilateral contract is a contract where each party has an obligation to others. Example, contract sale of goods. A unilateral contract is a contract whereby only one party has an obligation. Example, unilateral contract. Based on the reciprocal nature of interest of the subject, compensatory contract and uncompensatory contract. Make a distinction between compensation and damage compensation. Example 1, remunerated property deposit contract. Example 2, contract to keep property without remuneration. Based on the interdependence between contract, we have a main contract and subcontract. A principal contract is contract, the effectiveness of which does not depend on another contract. Whether an ancillary contract is a contract, the effectiveness of depend on the principal contract. For example, contract for house construction and accompanying interior design for this house, etc. Based on the effective time, we have a consent contract, formal contract, and actual contract. Based on a method and agreement to establish a contract, we have mutual agreement, model contract, civil law. A standard form contract means a contract contains terms and conditions which are prepared by a party based on a standard form requiring the other party to rely within a responsible period of time. If the offeree accepts, it shall be deemed to have accepted the entire contract provided by the inquirer. The standard form contract must be public in order to the party to know or should know the content of our contract. Procedure for announcement. of standard form contract shall comply with regulation of law. What about other type contract? The contract for the benefit of a third party and conditional contract. A contract for the benefit of a third person is a contract whereby contracting party must perform obligation for the benefit of a third person, and third person enjoy the benefit from such performance. The contract validity requirement. Theoretical framework for the contract effective time. A contract validity is determined by a set of legal conditions that ensure contract true nature is established. Subject condition. Participants in transaction have legal personality and or legal capacity in conformity with such transaction. Distinguish between a subject of contract and a subject of conclusion of contract. Subject contract must pay voluntarily. Case in which contract violated voluntary element. Contract failed, confused, deceived, or shift contract participants are not aware and of control their behavior. Article 123. Invalid of civil transaction due to breach of the legal prohibition or contravention of social ethics. Civil transaction with object and content which breach legal provision or which contravene social ethics shall be invalid. Legal prohibition means provision of law which do not permit entity to perform certain acts. Social ethics are common standard of conduct as between persons in social life, which are recognized and respected by the community. Consider the following situation. A and B sign contract for the sale and purchase a home. As a result, A shall build a house in District Y, City X for 10 billion Vietnam dong, with total space of 120 meters square. The two sides decided to include a clause in the contract stating that a notarization would be issued for only 3 billion Vietnam dong. What are your thoughts on a aforementioned agreement? So I'm sure you have an answer. Void contract and legal consequences. The definition of void contract. A contract does not comply with the condition of validity, so it has no legal value and flow does not give rise to right and obligation between the parties involved. Contracts that are voidable, both completely and partially invalidated. Article 130 of Civil Code. A civil transaction shall be partially invalid when one part of transaction is invalid, but such invalidity does not affect the validity of the remaining part. The term relatively invalidity and absolute invalidity, case of specific invalidity. Contract is void in specific cases. First, violation of prohibition is against social ethics. A false contract, then mistake in contract, the contract contains deception, and the contract is made on the basis of fear. Contract is formed by a person who is unaware of and uncontrolled of the act. The contract are formed and fulfilled by minor, people who have lost their civil act capacity, and the people who have difficulty with perception and behavior control. So we see Article 125. Article 125 states that a civil transaction of a person prescribed in clause 1 of this article shall not be invalid in any of the following cases. The civil transaction of a child less than 6 years of age or a legal incapacitated person established by his or her daily needs. Civil transaction only either arising right or exempting from obligation for the minor and a legally incapacitated person, the person with limited cognition and behavior control the person with limited legal capacity and their contracting parties. The legal transaction of which validity is recognized by the person established such transaction that become an adult or restore his or her legal capacity. In the event that contract is violated in terms of form, contract is matched in writing, but document is not in accordance with regulation, at least 2/3 of obligation agreed upon contract have been fulfilled. Second question, the contract is matched in writing but violates obligation of notarization and will office and has fulfilled at least 2/3 obligation agreed in contract. So I'm sure you have an answer. Legal consequences of void contract. Article 131 of Civil Code. On invalid civil transactions shall not give rise to change or terminate any civil right and obligation of the party as from the time and transaction is entered into, handling property when contract is invalid. Protection rights, third party when a contract is void. Article 133. In case where civil transaction is invalid, but the transacted property being a movable property is not required to be registered, and such property had already been transferred to a bona fide third party through another transaction. The transaction with the third party shall remain valid, except for the case of specific in Article 167 of this Code. In cases where civil transaction is invalid, but the transacted property is registered at a competent authority, and such property had already been transferred to a bona fide third party through another transaction, which is established according to that registration, such transaction shall remain valid. In cases where transacted property which is required to be registered had not registered at a competent authority, the transaction with a third party shall be invalid, except for cases the bona fide third party receives such property through an auction or a transaction with another party being the owner of such property pursuant to a judgment or decision of a competent authority. But thereafter, such person is not the owner of property as a result of judgment or decision being amended or annulled. The owner of property shall have no right to reclaim the property from the bona fide third party if the transaction with such party remains valid as prescribed in clause 2 of this article. But the owner may proceed against the party at fault to refund appropriate expenses and compensate for his or her damage. That's all the lesson about the introduction to the contract law. If you have any other question, please contact the National Institute of Intellectual Property. Nguyễn Thái Cường report from National Institute of Intellectual Property. Thank you again for your listening. Today, October 2021.